When a state government openly tells the courts that the Second Amendment doesn't protect the most popular rifle in America, you know something bigger is happening. That's exactly what Massachusetts just did. In their official response to a federal lawsuit filed by the Gun Owners Action League Goal, the NRA, and several local gun owners, the state boldly claimed that AR-15s and similar firearms aren't in common lawful use. Despite the Supreme Court's repeated recognition of those weapons under Hilaire and Bruin, this isn't just a fight over one state's gun law. It's a direct test of whether states can defy the constitutional boundaries set by the Supreme Court and still get away with it. The case, Hanlon v. Campbell, may very well determine if the Second Amendment remains a national guarantee or becomes a patchwork privilege dictated by each state legislature when the Gun Owners Action League Goal, the NRA, and several individual citizens filed their federal lawsuit against Massachusetts' new firearm law. Chapter 135 of the Acts of 2024. It sent shockwaves through the gun rights community. Officially named an act modernizing firearm laws, the legislation was framed as an update to outdated statutes. In reality, it represented one of the most sweeping gun bans ever enacted in state history. Under this new law, Massachusetts banned entire classes of firearms, including AR-15ES, AK pattern rifles, and many semi-automatic pistols and shotguns. The bill's language was deliberately broad, allowing the state to outlaw any firearm that shared design features with those listed as assault weapons. This approach mirrored strategies used in states like California and New York, both of which have faced years of costly legal challenges under the Bruin standard. But what made this case different was the timing and the legal momentum already building across the nation. Following the Supreme Court's Bruin decision in 2022, federal courts began striking down arbitrary firearm restrictions that lacked historical justification. That ruling forced every state to demonstrate that their modern gun control laws aligned with the historical tradition of firearm regulation at the time of the Constitution's founding. Massachusetts' new law seemed to ignore that mandate entirely. It criminalized firearms that are undeniably common, used by millions of Americans for sport shooting, home defense, and lawful carry. The plaintiffs argued that the law wasn't just unconstitutional, it was a calculated defiance of Supreme Court authority. In their complaint, Gall and the NRA-backed plaintiffs pointed out that AR-15 rifles are owned by over 20 million Americans, making them one of the most widely used rifles in the country. These firearms are not weapons of war, but civilian rifles with standard features long protected under federal and constitutional law. The lawsuit emphasized that the Second Amendment doesn't protect only flintlocks and muskets, but extends to all arms commonly possessed for lawful purposes. Just as Hilaire and Bruin confirmed, the plaintiffs also challenged several other controversial elements of Chapter 135. One section introduced strict transport and storage restrictions, effectively criminalizing routine activities like driving to a shooting range or taking a firearm to a gunsmith. Another provision created new reporting and registration requirements, sparking fears that Massachusetts was quietly laying the groundwork for a statewide gun registry, a move long opposed by both Congress and the firearms community. Beyond the legal text, the emotional core of the case lies in the human impact. Many plaintiffs are everyday citizens, law-abiding residents suddenly turned potential criminals for owning guns they've had for decades. Some are small business owners whose livelihoods depend on firearm sales, now made illegal under the new definitions. In interviews and public statements, Gold described this lawsuit as not just about Massachusetts, but about stopping a domino effect that could ripple across all blue states if the state succeeds in upholding Chapter 135. Others will adopt similar modernization laws, effectively rewriting the Second Amendment without Congress or the courts. For gun owners nationwide, Hanlon v. Campbell became more than a local fight. It symbolized the broader war between state-level activism and constitutional restraint. And for Massachusetts, it was a test of how far the state could push the envelope before federal courts finally drew a line. When Massachusetts filed its official legal response to Hanlon v. Campbell, it became immediately clear that this was no ordinary defense. The Attorney General's office didn't just deny the plaintiffs' claims, They launched a full-scale counterattack aimed at dismantling the foundation of the plaintiff's constitutional argument. The state's filing issued through the Secretary of Public Safety essentially reframed the Second Amendment debate itself. At the heart of Massachusetts' strategy is a bold and controversial position that AR-15s and similar firearms are not in common lawful use and therefore fall outside Second Amendment protection. That's a stunning argument, given that even the Department of Justice and numerous federal court opinions have recognized that millions of these rifles are owned legally across the country. To justify this claim, the state recycled the same line used in Haler, that certain weapons can be restricted if they are dangerous and unusual. But in Heller, that phrase applied to weapons not commonly possessed by law-abiding citizens. Massachusetts twisted that reasoning, suggesting that popularity alone doesn't prove constitutionality, an interpretation that directly contradicts both Haler and Bruin. The state's brief also invoked the 11th Amendment's doctrine of sovereign immunity, claiming that the state cannot be sued in federal court without its consent. This was not just a procedural tactic. It was a move to shut down the lawsuit entirely before a single piece of evidence could be presented. The filing argued that the plaintiffs lacked standing because they hadn't yet been arrested or prosecuted under the new law. A technical defense meant to sidestep the constitutional questions altogether. That argument, while clever, contradicts common sense. You shouldn't have to be jailed or fined to challenge a law that clearly threatens your rights. Courts have long recognized that the chilling effect of a criminal statute, especially one targeting core constitutional freedoms, is itself sufficient grounds to sue. Yet, Massachusetts hoped the court would dismiss the case on a mere technicality. Perhaps the most troubling part of the defense was the claim that firearm dealers and gun stores do not have independent Second Amendment rights, the state's logic. Because they're selling guns rather than using them personally, their business activities fall outside the scope of the right to keep and bear arms. This is a dangerous precedent. If accepted, it would mean the government could the firearm supply chain without ever having to touch individual ownership rights. A backdoor disarmament strategy. Legal scholars immediately took notice. Even commentators who generally support stricter gun laws admitted that the state's argument pushes the limits of constitutional interpretation. One attorney described it as a deliberate test case to see how far a court will let a state stretch the Second Amendment before it snaps. In addition, Massachusetts cited public safety statistics to justify its ban, claiming it would reduce mass shootings and violent crime, but those assertions were not supported by data. Studies from the Department of Justice's Bureau of Justice Statistics and independent research groups have shown no conclusive evidence that assault weapon bans reduce gun violence. Instead, most firearm crimes involve handguns, not rifles like the AR-15. To the plaintiffs and millions of gun owners watching nationwide, this response confirmed their worst fears that the state was less interested in safety than in creating a legal playbook for other states to follow. By mixing constitutional distortion with procedural roadblocks, Massachusetts was attempting to rewrite the Second Amendment through litigation. Groups like the Firearms Policy Coalition, FPC, and the Second Amendment Foundation, SAFF, quickly rallied behind GO's efforts. They called the state's position a calculated assault on constitutional order, warning that if left unchecked, this defense could serve as a blueprint for nationwide gun restrictions. For now, the legal battle is just beginning. But one thing is certain, Massachusetts isn't just defending a law. It's defending the idea that states can outmaneuver the Constitution. Whether the courts will allow it is the question that could reshape the future of the Second Amendment itself. The outcome of Hanlon versus Campbell could echo far beyond Massachusetts. This isn't just a local dispute over one law. It's a national test of how far states can stretch the limits of the Second Amendment before the federal judiciary steps in. If Massachusetts succeeds, it won't just validate one ban. It will hand every anti-gun state in the country a blueprint for bypassing Supreme Court precedent. Here's what that means in practice. A state could simply declare that a firearm, no matter how common, is not commonly used and then outlaw it. The Bruin test, which demands that modern gun laws align with the nation's historical tradition of firearm regulation, would become meaningless. Each legislature could invent its own definition of what the Second Amendment really means. turning a guaranteed right into a state-level privilege. That's why constitutional lawyers and gun rights advocates are watching Hanlon versus Campbell so closely. They know this case could become the next major Supreme Court showdown after Bruin. If the plaintiffs prevail, the ruling could strike down assault weapons bans nationwide, forcing states like California, New York, and Illinois to roll back their restrictions. But if the state wins, the consequences could be devastating. The decision would embolden legislators to pursue even more aggressive bans on magazines, ammunition types, or even optics. Under the same logic Massachusetts is using now, in effect, the Second Amendment would become a hollow symbol depending on which side of a state border you happen to live. Beyond the legal implications, this case represents a cultural and constitutional crossroads. Are we still a nation where rights are fixed by the Constitution? Or are we becoming a country where elected officials reinterpret those rights to suit their politics? The plaintiffs argue that this fight isn't just about guns. It's about restoring constitutional limits on government power. Gun rights organizations like the NRA, Firearms Policy Coalition, and Second Amendment Foundation have made it clear they'll pursue this case all the way to the Supreme Court if necessary. Legal analysts expect it could take years, but the trajectory is unmistakable. Hanlon versus Campbell has the potential to redefine the boundaries of state and federal authority on gun ownership. As history shows, the Second Amendment has survived every political era because ordinary citizens refuse to surrender their rights to political convenience. And once again, that battle is being fought not in Washington, but in the state courts, where freedom often rises or falls quietly, case by case. Every battle for the Second Amendment starts somewhere, and this one began in Massachusetts, the Hanlon vs. Campbell lawsuit has already revealed how far certain states are willing to go to test the Constitution's limits, twisting precedent and procedure alike to justify disarming their citizens. But this isn't just about AR-15's gun stores or a single state law. It's about whether our Bill of Rights still means what it says. If the courts side with the plaintiffs, it could mark the beginning of a national reaffirmation of individual liberty, a return to what Hilaire and Bruin promised. But if Massachusetts prevails, it will signal open season for states to rewrite constitutional rights by legislative decree. In the end, this case reminds us that freedom is never self-preserving. It depends on ordinary citizens standing their ground, holding the line, and defending the principles that built this nation.